Grand K Strategies presents Solutions to the FATCA Legislation. With the advent of the FATCA legislation, it will surprise many to realize there is a need to analyze the critical aspects of the Foreign Account Transaction Compliance Act to see who is genuinely affected by this so-called broad-based international law. Many believe the FATCA legislation is an attempt to curtail tax evasion and force compliance upon all Americans to pay their fair share of taxes to the U.S. government. This program provides a closer inspection to reveal some astonishing facts about how the U.S. government has applied its income taxation laws toward a far narrower audience than initially presumed. We'll reveal our proven solution to protect banking privacy for most Americans so they may continue to invest abroad. For non-U.S. bankers, our solution is the key to maintain the relationships that took years to establish and offers unique opportunities to actually increase its client base, all while keeping in step with the FATCA legislation and related tax treaties. This information will provide insight into the correct process we have developed to allow Americans to bank privately with any international bank that implements our solutions. To be clear, all applicable federal laws should be obeyed. Therefore, we will be showing you federal laws that you may not be familiar with unless you are one with a formal legal education. The national government plays a larger role today than was envisioned by the founders of the Constitution. As such, it is the duty of Americans to know the law and to keep the national government from falling into error. For those who are international bankers, this particular reference to foreign jurisdiction legislation is critical to your understanding of the latest impact related to FATCA laws and the treaties that have been implemented between the U.S. and non-U.S. governments. This video effort is based entirely upon federal laws related to FATCA and the federal income tax being properly applied based on those federal laws. Our intent is to provide you with the facts established by FATCA and the treaties the U.S. government has established with other nations regarding those who are the targeted audience of FATCA rules. All Americans living and/or banking internationally need to know the scope of FATCA law and to be able to articulate such to foreign financial institutions who may not be as fully aware as they may presume they are. FATCA is a creation of the U.S. Congress regarding the legal efforts of the national government to gain financial control over Americans who bank internationally. The target audience reflects those who are referenced within the scope of this statutory term in the Internal Revenue Code, also referred to as the IRC or Title 26, and is identified by the expression United States person or U.S. person. In order to clearly understand what this term means, one must first look at the definition of a statutory U.S. person. Within the IRC, the term U.S. person can be found at 26 U.S.C. section 7701A30. The term United States person means A citizen or resident of the United States, B, a domestic partnership, C, a domestic corporation, D, any estate other than a foreign estate within the meaning of paragraph 31. E, any trust if 1. A court within the United States is able to exercise primary supervision over the administration of the trust, and 2. One or more United States persons have the authority to control all substantial decisions of the trust. Basically, a U.S. person is a statutory legal fiction created by the U.S. Congress, and when they reference the term citizen, they are referring to a statutory definition based on the jurisdiction of the U.S. territories, not the 50 states of the Union. Thus, this definition is illustrating a legislative jurisdiction, not a constitutional one. The legislative jurisdiction is limited to the District of Columbia and U.S. territories and applies to this definition. When you review 26 U.S.C. section 7701A30A, most Americans think this subset expression U.S. person defines them. Those who do so have overlooked the distinction of a statutory expression of a citizen of the United States versus the everyday expression most are familiar with. Grand K Strategies has chosen the non-statutory phrase of American national to reduce or even eliminate the confusion over the ambiguous terminology that the national government uses. American national will be defined later in this program. Senator Carl Levin of Michigan has openly stated in his drive to push the legislation for FATCA through the U.S. Congress that, quote, any U.S. person who has an offshore bank account is ipso facto engaged in tax evasion. Thus, he claimed that by the fact itself, or the very nature of possessing an international bank account, any statutorily defined U.S. person is immediately guilty just by having an international bank account, which in his view is sufficient evidence of tax evasion. What he failed to present was an explanation of what a statutory U.S. person actually means. His intentional ambiguity brings to mind a statement made by former President of the United States, Franklin D. Roosevelt, when he stated, quote, governments never do anything by accident. If government does something, you can bet it was carefully planned. Perhaps now would be a good time to introduce some historical references as to where the national government began to express itself with the international ability to tax its statutory U.S. citizens who live outside the geographical boundary of the United States. But before we take a historical look, you should know that the terms U.S. citizen and United States have unique meanings in regard to FATCA today, as well as the historical decision made by the U.S. Supreme Court way back in 1924. Please note the following definitions are statutory creations of the U.S. Congress and may start to open your mind as to the reality of what is going on. Once you get your mind around the meaning of these few terms, you will be able to deal more effectively with the paradigm shift you are now being introduced to. If you were asked by a stranger, are you a U.S. citizen and do you live in the United States? What would be your response? Okay, now for the definitions created by the U.S. Congress. There are two criteria in addressing the questions above on U.S. citizenship. They are 1. Those born in the United States, and 2. Those that are subject to the jurisdiction of the United States, meaning the national government. Here you see two definition sections that should shed some light. The two criteria are found in 8 U.S.C. section 1401A and the section 2689 in the American Journal of Jurisprudence, which is a legal encyclopedia. If you said yes to being identified as a U.S. citizen, then you are declaring on any federal form or to any federal official that you are one who meets the two criteria for one who is a person born in the statutory United States and subject to the jurisdiction thereof. You are also stating that you were born in a territory over which the statutory United States is sovereign. As you probably realize, U.S. territories and possessions are not part of the constitutional republic, the now 50 states of the Union. But if you declared that you are a statutory U.S. citizen, you are thus subject to the national government via its statutory laws. As to the second question asked by the stranger, do you live in the United States? 26 U.S.C. section 7408D can help you accurately answer that one. Quote, if any citizen or resident of the United States does not reside in and does not have his principal place of business in any United States judicial district, such citizen or resident shall be treated for purposes of this section as residing in the District of Columbia. You can see very clearly that you are indicating to any federal official or identifying on any federal form that your domicile or residence is in the District of Columbia and not within the constitutional republic, if you do not know how to correct such a false presumption. For those in the international banking community, this should be a startling revelation as to the hidden meanings of terms not precisely defined to eliminate presumptions. These actually create presumptions that the national government can use for its benefit. As expressed in 26 U.S.C. section 911D3, you are stating your agreement with the fact that by your choice of domicile being within the statutory United States, meaning the District of Columbia or such U.S. territories, you are then subject to that jurisdiction, the District of Columbia. It does not matter to the national government whether you choose your tax home location geographically or statutorily. You can state your domicile to be within the District of Columbia in a geographic sense, or it can be stated by statutory reference, such as IRC Section 7408D. The whole idea is for the national government to get you to identify yourself as being within their limited jurisdiction, in which you become classified as federal property and under their dominion and control. Once you do so, then you are a statutory U.S. citizen or resident alien, no matter where you live on Earth. As such, you are the property of the national government, and the government views you as its property, in which they have dominion and control over you in taxation matters related to the federal income tax and now by FATCA. If you will permit just one more definition, the term individual referenced in 26 U.S.C. 911D3 is found at 5 U.S.C. section 552A, A2. The term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. So this reinforces the linkage of any statutory U.S. citizen to one with a domicile or residence in the District of Columbia, and that they have a tax home in the District of Columbia, whether they actually live there or any other place in the world. Back in 1924, the United States Supreme Court decision in Cook v. Tate was heard by former Chief Justice William H. Taft, the former president who wrote the legislative intent of the 16th Amendment. Let's take a brief detour to review the 16th Amendment from a historical perspective as well. Then we will return to the Cook v. Tate decision. While Taft was president, he was told by the U.S. Supreme Court in 1895 that any attempt on the part of the national government to impose a federal income tax upon the states of the Union without regard to the rule of apportionment was held to be unconstitutional. The reason the Supreme Court stated its decision was that any such avoidance of the rule of apportionment as mandated upon the national government in Article 1, Section 2, and Section 9 amounted to a direct tax and could only be imposed by the rule of apportionment according to population. The national government cannot apply its statutory laws within the constitutional republic, as such would be an unconstitutional act. Thus, for the 16th Amendment to be accepted, it could only apply to a separate and distinct jurisdiction. The only distinction for that to be legal is the municipal jurisdiction of the District of Columbia. Former President Taft wrote the legislative intent of the 16th Amendment, and in that document he stated in his letter to the U.S. Congress that, "I therefore recommend to the Congress that both houses, by a 2/3 vote, shall propose an amendment to the Constitution conferring the power to levy an income tax upon the national government without apportionment among the states in proportion to population." Note that he had to specify the tax was only to be levied upon the national government, not the American people living and working in the 50 states of the Union. Returning to the Supreme Court case of Cook v. Tate, this decision was based on the status of Mr. Cook claiming he was a U.S. citizen who was living in Mexico manufacturing yachts. After reading the decision of the case, it is clear Mr. Cook did not properly distinguish the definition of the term U.S. citizen. He was referencing to that of the national government's statutory definition of that term. The decision in Cook v. Tate stated in part, "The person receiving the income and the property from which he receives it must both be within the territorial limits of the United States to be within the taxing power of the United States. The power of the United States to tax a foreign-built yacht owned and used during the taxing period outside the United States by a citizen domiciled in the United States was sustained." For a clearer context, if one owns property, like a house, in several different countries, then the homeowner still retains ownership of his or her property, even when not physically present at the property wherever it is located. This is how the national government views those who are its property, and thus subject to its limited territorial jurisdiction, no matter where they might be physically located. Thus, for those who identify their status as Mr. Cook did by claiming to be a statutory U.S. citizen, they now face the issues of FATCA and continual federal income taxation. More and more, the land of the free seems to be a concept that has been modified to the extent that it is no longer a reality. Therefore, the statutory U.S. citizens who are a subset of U.S. persons are true U.S. taxpayers targeted under the FATCA rules. For those individuals, They are under the dominion and control of the national government and have to deal with the reality of the FATCA issue. FATCA has been well planned. The FATCA wording used illustrates a skillful representation of those who have a command of the law, so that the obvious is unclear to the average American national who does not possess such legal skills. It is very easy for those with such skills to use Machiavellian wording to achieve their goal and keep most American nationals and international bankers in the dark. When most American nationals do not understand the distinction of a statutory term vis-à-vis the routine expression of this term, it is easy for those in the national government to take advantage of that situation. Americans have routinely inferred that this statutory set of rules under FATCA identify them as being a target of the FATCA rules now found in Chapter 4 of the IRC. This is no doubt part of the intent, as there is no specification to the contrary on the part of the national government stated in the FATCA legislation and treaties with foreign governments. Overall, the national government has at least temporarily succeeded in their attempt for the first time in world history to extend legislation of one nation over jurisdictions that are foreign to that of the District of Columbia. This can lead to more actions by other nations in the future, which will be the destruction of current jurisdictional integrity of sovereign nations if it continues. Other nations may also seek extraterritorial jurisdiction over the sovereignty of foreign nations for yet unsuspected purposes. You might want to take time to review sections 1471, 1472, and 1473 in Chapter 4 of the IRC and search for the statutory term U.S. person frequently used in these sections. However, you will never see any detailed explanation of what that term means, or that the term is a mere statutory expression directed only toward those that the national government considers being its property. As with any property, the owner has the right to control what they own. Thus, statutory U.S. persons are legal expressions of property belonging to the national government. The U.S. Congress enjoys a statutory basis to fully control everything under its jurisdiction. With the FATCA publication Form 8938, there is only the slightest hint of the existence of non-resident alien individuals, American nationals, who do not have to file an income tax return. Those in the U.S. Congress tend to think differently and express their political ideas in semantics that contain, in parts, a hidden message that is not perceptible when such expressions are used to target an unsuspecting audience. Regarding international banks, they too have fallen prey to the semantic gamesmanship utilized by the politicians that make up the U.S. Congress. It is all a political game to those who are legally trained. Rarely will any politician divulge any vital information as to the meaning of the words they use. Media reporters appear to be willing lemmings to such manipulations of political words of art. For some strange reason, they fail to ask the politicians what their terms actually mean and where they are published. So, FATCA rules were created by politicians in the U.S. Congress, targeting their taxation efforts toward American nationals in a sub silentio legislative design, simply due to their having an international bank account. Of course, it's all about money and their efforts to gain control over it. American nationals are now negatively impacted by FATCA rules, even when they are not the proposed target audience. International bankers do not seem aware of the full extent of the semantic games being played upon them and their American clients. Lack of knowledge greatly impacted their client base with a huge outflow of funds. The use of FATCA rules and the implied application to the American client base by the extra-jurisdictional efforts of the U.S. Congress has put unnecessary stress on Americans living in Europe and abroad. There are a number of reasons why any American national may prefer to utilize the banking services of what are referred to as foreign financial institutions, or more commonly, international banks. Here are just a few ideas on why American nationals may legitimately prefer to bank internationally, and are provided to show you that tax evasion is not the reason ipso facto, as Carl Levin stated. 1. Affluent American nationals have placed a large portion of their asset portfolio in international banks for diversification of assets. Putting all your eggs into a single basket is not a good idea if that basket later is discovered to have a hole in the bottom. One can never assume that bank solvency will be viable for the years ahead based on the fact that it was for all the prior years. 2. Professional services provided by foreign financial institutions may be more appealing for a number of reasons, such as location, convenience, rate of return, and certainly a personal preference of the account holder with those in the bank that they have confidence in. 3. For those American nationals who are less affluent, an international bank is critical to handling the everyday banking needs when such American nationals live and work in scattered areas of the world. FATCA is disrupting that needed service from the presumptions the foreign financial institutions make about these American nationals. 4. It provides for currency diversification away from U.S. dollar concerns regarding debasement that originated back in the early 70s under the Nixon administration. So, FATCA has some problems if the targeted audience of U.S. persons actually includes all American nationals within its legislative scope. It doesn't. But there is a severe lack of awareness of these legal facts to support the American national living in foreign countries separate from FATCA. To date, FATCA continues to hurt the individual American national and the international banking community. Most international bankers don't know the full extent of the U.S. tax laws that has been presented here. They have been focused on the storm instead of establishing a proactive way to maintain their American client base by the lack of knowledge to prepare a viable business strategy to deal with these issues. With an open-minded consideration of the legal facts presented, this situation does not have to remain a blight against American nationals and their chosen international bank. A federal appellate court shows that in the constitutional republic, there are two distinct groups in regard to U.S. income tax liability. Only one of those groups actually bears any responsibility for that federal municipal tax. The reason is the foundation of the legislative intent of the 16th Amendment. Let us explain this by showing you what this federal appellate court stated. In the 1972 case of Economy Plumbing and Heating versus the U.S., this court stipulated the following. Revenue laws relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedures are prescribed for non-taxpayers, and no attempt is made to annul any of their rights or remedies in due course of law. With them, Congress does not assume to deal, and they are neither of the subject nor of the object of federal revenue laws. What you have been presented with is the truth. Initially, the truth may be hard to fathom, but it is still the truth. There are indeed two separate and distinct groups in the constitutional republic. The largest group, American nationals, have no liability for the federal income tax. Lawful non-taxpayers are not to be labeled as tax protesters because their earnings are not within the scope of federal tax laws. These non-taxpayers have rights which are unalienable and are not a FATCA target. This federal court shows that all revenue laws, including FATCA, only relate to those who are U.S. taxpayers. Such claims cannot be legally made against those who are non-taxpayers. Deloitte Touche Tohmatsu Limited, a UK-based private accounting firm, has published a document about FATCA called FATCA Frequently Asked Questions. It states in Section 62 of their publication that non-U.S. persons will not be subject to FATCA reporting or withholding. This is additional evidence of the existence of a non-U.S. person. Deloitte confirms that the target audience are those who are U.S. persons or specified U.S. persons in Section 1 and 5 respectively. Furthermore, in Sections 17, 33, and 55, Deloitte stipulates FATCA provisions only apply to withholdable payments of interest from sources within the United States, as well as any gross proceeds from the sale or disposition of U.S. property of a type that can produce interest or dividends. Grand Case Strategies can assist international financial institutions as well as American nationals who are non-U.S. persons by establishing legal documentation clarifying their true status of non-U.S. person account holders. Our documentation was designed to address all aspects of FATCA rules so that there is no violation of any treaty or government regulation related to FATCA against American national clients. Any international financial institution seeking our services will never have to fear from lack of compliance with the current FATCA rules. Compliance is only needed for those who are the targeted audience, and not to non-U.S. persons. We do not interfere with those obligated under FATCA rules and international treaties between foreign governments and the U.S. government. That would be a huge mistake, so we take the time to let you know that we do not ever intend to create that kind of consternation. Our firm is founded on legal knowledge for the purpose of distinguishing those who are American nationals from the targeted audience intended by FATCA rules. Such a relationship will also address the recapturing of the former embedded base of American clients, as well as clients from competitive banking institutions who are outside the scope of FATCA rules. To keep this conversation lively, we will soon show you that American nationals have never been lawfully imposed with any obligation to file or pay a federal income tax. This will be proven to not have any tax protester motive as part of our legal revelation. All comments will be based entirely upon enacted federal tax laws. That is our commitment, and the reason that any financial institution seeking services from our organization will be fully documented and in full compliance with the U.S. tax law pertaining to FATCA. The U.S. government can then be provided with copies of the legal documentation from each client and presented to the banking institution for assurance of all concerned. The U.S. government has stated in the FATCA guidelines the legal facts of U.S. tax law related to FATCA. There would never be any need for concern, nor would the U.S. government be foolish to risk exposure to the world should they attempt to extend FATCA beyond the targeted audience of only statutory U.S. persons. Our solution does not complicate existing tax treaties. This is a significant benefit to each international bank, as it can proceed with confidence to eliminate all reporting and withholding of all non-U.S. person accounts. FATCA rules simply do not extend over those American nationals who are not identified as statutory U.S. persons. This is a central theme of Grand Case Strategies to assist the international banking community to form a clear foundation on the differences in definitions and how to implement a new strategy that both maintains banking privacy and complies with intergovernmental treaties. Our resources are ready to implement this process. By now, you might be thinking about the meaning we apply to our term American national. What we mean by this non-statutory term will set you apart from any statutory reference to the term U.S. citizen. We define the non-statutory term American national to mean those who were born in the constitutional republic, the now 50 states of the Union, or those who were born to parents of which at least one was born in the 50 states, or those who were naturalized and became a member of the constitutional republic. For the benefit of American nationals living in a foreign country, we can assist those who wish to establish an international banking presence. For some basic information on how we can assist you, we recommend that you locate the IRS Form 8938 to begin your understanding of how FATCA does not apply to you unless you are one listed as a specified individual. Such specified individuals are the targeted audience we have already alluded to as statutory U.S. persons. The IRS Form 8938 and FBAR requirements address who must file in these documents. As you may have suspected by now, both of these forms address only the targeted statutory U.S. persons. As you review Form 8938, section Who Must File, you will see the opening statement. Unless an exception applies, you must file Form 8938 if you are a specified individual. Pay particular attention to the first 4 words, unless an exception applies. That is a very important statement which indicates that an exception does exist. Form 8938 states the meaning of the term exception. You will find the statement related to the exception expressed as meaning no income tax return required. If you do not have to file an income tax return for the tax year, you do not have to file Form 8938. Based on the legislative intent of the 16th Amendment and your understanding of it in context to the avoidance of the rule of apportionment in this amendment, the federal income tax was only levied upon the jurisdiction of the national government, which is commonly known as the District of Columbia. Federal Attorney Michael L. White has stated in a legal opinion letter to American National in Cicero, Illinois, quote, "Our records indicate that the Internal Revenue Service has not incorporated by reference in the Federal Register a requirement to make an income tax return." Federal laws reflect the design of the 16th Amendment. Thus, the exception referenced in Form 8938 about not being required to file an income tax return must apply toward someone, like the non-taxpayer group, or else why waste the time to make the reference for the exception in the first place? This is again supported by the Federal Appellate Court in the Economy, Plumbing, and Heating v. U.S. There are indeed two separate and distinct groups referenced as taxpayers and non-taxpayers. Those who are lawful non-taxpayers are ones who clearly meet the exception as stated in Form 8938. So you might be thinking, who are those within the non-taxpayer group? All references are clearly stated, but at the same time there is something vague about exactly who they are and where they live and work. When federal laws are published in the Federal Register, one knows that those implementing regulations then apply within the 50 states of the Union. This is explained in the Federal Register Act, 44 U.S.C. Chapter 15. When there are no implementing regulations published in the Federal Register, then those laws do not apply toward or extend into the jurisdiction of the 50 states. Those who work for the national government are those who derive income that is effectively connected with the conduct or performance of the functions of a public office, a statutory trade or business, per U.S.C. 26, Section 7701A26. Clearly, these are a subset of U.S. taxpayers and have an obligation to file and pay that municipal income tax that is lawful for those domiciled in Washington, D.C. and working in some federal trade or business by holding a public office. Statutory U.S. persons are also part of the larger group identified as U.S. taxpayers. The difference between a statutory U.S. citizen vis-a-vis a citizen of the constitutional republic, where the U.S. Supreme Court stated to the national government in 1895 that a federal income tax could not be applied without the rule of apportionment, makes this group those who are lawful non-taxpayers. Non-resident aliens describe American nationals because those who live and work in the 50 states are non-resident to the geographical area where the federal income tax was levied, the District of Columbia. They are also alien to all federal laws that do not extend into the jurisdiction of the constitutional republic, the 50 states, and they are not statutory U.S. citizens, a subset of statutory U.S. persons. Non-resident alien is the term the U.S. Congress has chosen to use for describing what we refer to as American national. Granted, it is so vague for most Americans that it was important to make a full display of the fact that the U.S. Congress was referring to American nationals who fall into the non-taxpayer group. Worth repeating, we prefer not to contribute to the semantic confusion by even using the term U.S. citizen, due to the duality of meanings that are never specified by definition on the part of the IRS. Therefore, we much prefer the non-statutory term American national to eliminate any confusion. From the facts of law, we trust you begin to see that an American national has no lawful obligation or requirement to file and pay the federal income tax imposed upon the municipal jurisdiction of the District of Columbia and those who work for it. As such, the FATCA rules do not apply to this audience. Next, you can locate the section related to a new term referred to as specified individual. You will find that the IRS claims one is a specified individual if you are one of the following: a U.S. citizen, a resident alien of the United States for any part of the tax year, a non-resident alien who makes an election to be treated as a resident alien for purposes of filing a joint income tax return, or a non-resident alien who is a bona fide resident of American Samoa or Puerto Rico. While you are reviewing this information, please keep in mind that the IRS is only referring to statutory terminology that only applies toward those who are subject to the jurisdiction of the national government. By now, you should know what the IRS is referring to with the expression a U.S. citizen. If not, then please note to look up 8 U.S.C. Section 1401A and the American Journal of Jurisprudence, section 2689, which defines a statutory citizen as one who is born in the United States and subject to United States jurisdiction. The second listing under specified individual addresses those who are resident aliens of the United States. This group does not consist of any American nationals. These are foreigners. The third listing is where a lot of people get confused very quickly. The expression of a non-resident alien is a new term to most. Pay particular attention to the fact that those in this group must first make a voluntary election to be taxed by the national government as if they were a U.S. resident alien. Fortunately, we have located statutes created by the U.S. Congress in which any non-resident alien who previously made that election, with or without awareness to its full ramifications, may terminate that election and return to their original status in the non-taxpayer group. This is a key component of the package we offer to American nationals wishing to bank internationally, retain privacy, and avoid the pesky FATCA legislation. For a definition of this term, non-resident alien individual, one has to refer to 26 U.S.C. section 7701 B1b. This term is defined in the IRC as follows. An individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States. You have just noticed that this definition is not really a definition. This statement only tells the reader what a non-resident alien is not, rather than what a non-resident alien actually is. There is more to understanding exactly what a non-resident alien individual actually is from what you have just seen. You can find a better understanding of exactly what this term means by looking at 26 CFR section 1.871-1 B4. Quote, for special rules applicable in determining the tax of a non-resident alien individual who has lost U.S. citizenship with a principal purpose of avoiding certain taxes, see section 877. One has to review 26 CFR section 1.871-1A next to find that the U.S. Congress states that such non-resident alien individuals are only liable for the federal income tax if they derive income from a statutory trade or business within the statutory United States. All public officers are located in the District of Columbia, the statutory United States. So if you do not derive income that is effectively connected with the functions of a public office, you are not a statutory U.S. person, and you do not derive income from sources within and without the statutory United States, as listed in 26 U.S.C. section 861A. Or as a non-resident alien, you have not made an election to be taxed like that of a U.S. resident alien. Then you have no liability for the federal income tax. If you did make an election by voluntarily filing your first Form 1040, then you may terminate that election. There is no federal income tax liability if you meet the FATCA exception and are not a specified individual as stated on Form 8938 if 1. You do not derive income from a federal trade or business, a public office, or 2. You are not a statutory U.S. person, or 3. You do not derive income from sources within or without the statutory United States that pertains to the sale or disposition of federal property listed under 26 U.S.C. section 861A, or 4. You are a non-resident alien who has not made an election or has at least terminated that election. Thus, other than living in American Samoa or Puerto Rico, the voluntary election is the only method by which any non-resident alien individual can become liable for the federal income tax. Fortunately, we offer a solution to resolve the issue for those American nationals who have made an unwitting election under 26 U.S.C. section 6013G or H. The revocation of election process will allow any American national to become fully segregated from inclusion under the FATCA rules, as it was created by the U.S. Congress to allow Americans to leave the U.S. tax system if they desire to do so. When you consider all that we have presented on FATCA, it comes down to the individual determining if they are one who is within the scope of the targeted group, those who are statutory U.S. persons. As the Federal Appellate Court indicated, the U.S. Congress only addresses the statutory laws toward those who are its property and those subject to its jurisdiction. The solutions to FATCA for the foreign financial institutions are: 1. To contact us for a detailed meeting on what we can provide to the bank to stay within the guidelines of FATCA and to gain growth in the American national client base. 2. To learn how to avoid conflict with the U.S. government FATCA guidelines. 3. To attain understanding about how not to act in such a manner that would cause your own government to place pressure due to the current tax treaty with the U.S. government. And 4. To gain a substantial growth in lost client base with proper identification of American nationals as being non-U.S. persons who are not the target audience of FATCA rules. As you have learned, there is much more to this topic on FATCA than first was perceived. If you are a principal with an international bank, you need to strongly consider contacting us at your earliest convenience to gain insights into what we have established regarding federal tax laws. It would be best to schedule a physical meeting at your banking location to discuss these matters further and to answer any questions that may still arise. The FATCA legislation is a complex one. What we have presented is only a small but significant part of the complete landscape of what we can offer the international banking community. For those who are American nationals and are in need of services to prepare documentation to their international bank, we will need to coordinate all efforts with you and your banker simultaneously. Our website is www.grandkstrategies.com. You can email us to begin your inquiry at grandk@gmx.com. Thank you for listening to our presentation, and we look forward to serving you.